Welcome to Easy Learning. Exercise number 4. Invoking the jurisdiction vested in the Settlement Commission by Section 127C(5)(a) of the Customs Act, the petitioner moved an application for rectification of the aforesaid final order dated 1st November 2018. It was sought to be urged in the said application that the Settlement Commission had imposed penalty on the petitioner on the basis of an erroneous finding that the petitioner had consciously chosen to spread out its imports through various ports and had thereby devised a planned strategy to evade customs duty. No such allegation, the petitioner sought to point out, was contained in the show cause notice dated 24th March 2017 supra issued to the petitioner, pointing out that the penalty imposed by the Settlement Commission was exorbitant. The rectification application prayed that the error apparent on the face of the order dated 1st November 2018 supra be rectified and the decision to impose penalty on the petitioner be accordingly reconsidered. The only contention advanced by learned counsel appearing for the petitioner was that the decision of the Settlement Commission to award a penalty to the petitioner was vitiated, as it had been taken on the basis of an erroneous finding regarding the petitioner having consciously chosen to spread out the imports through the various ports with a view to test his chances of success in evasion of duty at different ports. There was, it is pointed out by the learned counsel, no such allegation in the show cause notice dated 24th March 2017 issued to his client. Ergo, the Settlement Commission erred in returning the said finding. Consequently, the penalty imposed on his client, being based on the said finding, was also unsustainable, and therefore the Settlement Commission ought to have reversed the decision to award penalty while adjudicating the rectification application filed by him. In that view of the matter, it cannot be said that the decision of the Settlement Commission to impose penalty on the petitioner suffers from any error apparent on the face of the record. Consequently, the impugned condition of the Settlement Commission to reject the petitioner's application for rectification too does not suffer from any such infirmity as would call for interference by this court in exercise of its writ jurisdiction. The petitioner grievance regarding the quantum of penalty awarded too fails to impress. We are in agreement with the finding of the Settlement Commission that the petitioner had deliberately sought to evade customs duty by undervaluing its imports. No doubt the petitioner made a clean breast of its affairs and did not dispute the duty liability as quantified in the show cause notice dated 24th March 2017 supra. That by itself would not, however, entitle the petitioner to immunity from penalty. We clarify that applications under Section 127(b)(5) have to be heard in open court by the Settlement Commission, and orders disposing of such applications are required to be reasoned. We are not satisfied that the decision of the Settlement Commission to impose penalty on the petitioner suffers from any infirmity. Full stop.